May I request the Registrar General High Court of Meghalaya to escort the honorable dignitaries to the dais. With the permission of His Lordship, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman Nalsa, may we commence with today's program. Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman Nalsa, Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, Honorable Mr. Justice Sanjeev Banerjee, Chief Justice High Court of Meghalaya and Patron-in-Chief Meghalaya State Legal Services Authority, Honorable Mr. Justice H.S. Thankhill, Judge High Court of Meghalaya and Executive Chairman Meghalaya State Legal Services Authority, Honorable Mr. Justice W. Dengdo, Judge High Court of Meghalaya, Honorable Executive Chairmans SLSAs, Honorable Chairman SLSAs, Member Secretary Nalsa, Member Secretary SLSA, dignitaries, ladies and gentlemen, good morning and a warm welcome to the East Zone Regional Conference on the theme Enhancing Access to Justice, held here in the capital city of Meghalaya, Shillong, by the Meghalaya State Legal Services Authority under the aegis of the National Legal Services Authority. Endowed with natural beauty, the state of Meghalaya is inhabited by the tribes Khasis, Garos, Panars, and other tribes. It is a privilege to have amidst us distinguished dignitaries, ladies and gentlemen. May I request Honorable Lordships on the dais to kindly light the ceremonial lamp. Light symbolizes abundance, prosperity, and knowledge. The presence of knowledge removes ignorance, like how the presence of light removes the darkness around us. Thank you, Lordships. May I request His Lordship, Honorable Mr. Justice Sanjeev Banerjee, Chief Justice High Court of Meghalaya and Patron-in-Chief Meghalaya State Legal Services Authority, to do the honor of felicitating His Lordship, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman Nalsa, with a shawl, karindia, and a pot of plant. Jain rindia, a small traditional stole, is commonly worn by the tribals in Meghalaya. Weaving with fabric form an important identity that has existed for centuries among the Ari weavers of Meghalaya. From mesmerizing hills of Riboy district, Meghalaya, comes the exquisite hand-spun and hand-woven rindia stole in natural hues of vegetable dyes, Kajayan rindia. Thank you, Lordship. May I request His Lordship, Honorable Mr. Justice H.S. Thank you, Judge High Court of Meghalaya and Executive Chairman, Meghalaya State Legal Services Authority, to felicitate His Lordship, Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, with Kajayan rindia and a pot of plant. Thank you, Lordship. May I request Shri A. Boklankar Umnoy, Registrar General High Court of Meghalaya and Member Secretary, Meghalaya State Legal Services Authority, to felicitate His Lordship, Honorable Mr. Justice Sanjeev Banerjee, Chief Justice High Court of Meghalaya and Patron-in-Chief, Meghalaya State Legal Services Authority. Thank you, sir. May I request Shri Alan B. M. Ripnar, District and Sessions Judge and Chairman, DLSA West Garo Hills District, to felicitate His Lordship, Honorable Mr. Justice H.S. Thank you, Judge High Court of Meghalaya and Executive Chairman, Meghalaya State Legal Services Authority. Thank you, sir. May I now request Srimati Dashaleen Kharbateng, District and Sessions Judge and Chairperson, DLSA Shillong, to felicitate His Lordship, Honorable Mr. Justice W. Dingdo, Judge High Court of Meghalaya. Thank you, Madam. Now we are going to play the Nalsa theme song, Ek Muthi Asman.
एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके लिए, विश्वास न्याय का सबके लिए। अपने इस हिंदुस्तान पर हक हमारा भी तो है, इंसाफ के इस आशिया पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां पर हक हमारा भी तो है।
ये ना सोचो दर्द हमारा कहीं सुना न जाएगा, अब न्यायालय खुद चलकर चौपालों तक आएगा।
लाचारों को न्याय मिलेगा, दुखियारों को न्याय मिलेगा, कमजोरों को न्याय मिलेगा, मजलूमों को न्याय मिलेगा। अपने इस हिंदुस्तान पर हक हमारा भी तो है, उम्मीदों के इस गुलसितां पर हक हमारा भी तो है। एक मुट्ठी आसमां पर हक हमारा भी तो है, एक मुट्ठी आसमां
और कमजोरों को मुफ्त एवं सक्षम कानूनी सहायता के लिए प्रतिबद्ध विधिक सेवा प्राधिकरण नालसा, न्याय सबके लिए।
May I now request His Lordship Honorable Mr. Justice H.S. Thankyew, Judge High Court of Meghalaya and Executive Chairman Meghalaya State Legal Services Authority to kindly deliver the welcome address.
Honorable Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman, National Legal Service Authority. Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India. Honorable Mr. Justice Sanjeev Banerjee, Honorable Chief Justice of the High Court of Meghalaya and Patron-in-Chief of the Meghalaya State Legal Services Authority. My colleague, Honorable Mr. Justice W. Dingdo, Judge, High Court of Meghalaya and Chairman of the High Court Legal Services Committee. Honorable Mr. Justice Rajiv Shakder, Judge, High Court of Delhi and Member Advisory Board, Nalsa. Honorable Mr. Justice Arun Bansali, Judge, High Court of Rajasthan and Member Advisory Board. Honorable Mr. Justice A.K.J. Nambiar, Judge, High Court of Kerala and Member of Advisory Board Consultative Panel, Nalsa. All the Honorable Executive Chairpersons of State Legal Service Authorities, all the Honorable Chairpersons of the High Court Legal Service Committees, the members of the Meghalaya State Legal Service Authority, all the member secretaries of the respective state legal service authorities, all the chairpersons, secretaries of district legal service authorities, other officers, members of print electronic media, ladies and gentlemen. I deem it a privilege and an honor to stand here today to deliver the welcome address in this inaugural function of the East Zone Regional Conference of State Legal Service Authorities on the theme Enhancing Access to Justice. Access to justice is a basic human right as conferred by common law. And the word access itself signifies a right to move towards a remedy. The right to legal aid, as is now, is a constitutional right. And the dispensation of justice to all, irrespective of one's social and economic status based on the rule of law, is no doubt the highest, is a guarantee that every government should ensure to its citizens. Justice, no doubt, is the highest virtue of the human spirit and the bedrock of most philosophies human beings have ever founded. The concept of equal justice visualizes a political and legal order in which justice will be brought within the reach of all, those blessed by the wealth and those depressed by poverty. Legal aid in this context has been recognized the world over as a mechanism that provides and ensures easy and inexpensive access to justice, and has now been evolved as a distinct human right that secures the right of citizens. However, there is still a wide gap between the goals that are set and the goals that are met, especially with the fast evolving landscape in the area of various types of legal services programs that are now conducted. This regional conference to examine ways to enhance access to justice is a step in the right direction to ensure such access reaches all deserving sections of society. It is indeed a pleasure to welcome His Lordship, Mr. Honorable Justice Sanjay Kishan Kaul, Judge of the Court of India, and Executive Chairman NASA to this August gathering. We are delighted that you are here with us today, sir, in Shillong to be part of the regional conference. Honorable Justice Sanjay Kishan Kaul, since assuming the mantle of Executive Chairman, NALSA, His Lordship devoted much time to various legal services programs across the country and has given invaluable guidance, support, and direction to legal service programs initiated by various state legal service authorities, not only in the Northeast, but in other states as well. Considering His Lordship's vast experience and knowledge, it will be a great privilege and pleasure to be able to listen to His Lordship's address to us on this occasion. On behalf of all of us, I extend my heartiest welcome to Your Lordship. We're also happy to have in the midst Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India. His Lordship's presence amongst us is indeed a source of inspiration to this gathering. On behalf of all of us, I welcome your Lordship, and I believe that any inputs Lordship might share with us today will greatly benefit this conference. We look forward to His Lordship's address. It is my pleasure to welcome our Chief Justice, Honorable Mr. Justice Sanjeev Banerjee, Chief Justice of the High Court of Meghalaya and Patron-in-Chief, Meghalaya State Legal Service Authority, to this occasion. As Patron-in-Chief of the Meghalaya State Legal Service Authority, he has provided the much-needed support and guidance to the State Legal Service Authority in implementation of various legal services activities in that state, including hosting of this wonderful program today. And it would be a pleasure to hear the Lordship's address to us in a short while from now. I extend a warm welcome to my brother judge of this High Court, Honorable Mr. Justice Bridgingdo, and Chairman of the High Court's Legal Services Committee, whose vast experience in the field of legal services and activities in the state has contributed to the development of legal service institutions and activities. I also extend a warm welcome to Honorable Mr. Justice Rajiv Shakhter, Judge, High Court of Delhi, and member of the Advisory Board, NALSA. Honorable Mr. Justice Arun Bhansali, Judge, High Court of Rajasthan, and member Advisory Board, NALSA. Honorable Mr. Justice A.K.J. Nambiar, Judge, High Court of Kerala, and member Advisory Consultative Panel, NALSA. I believe their Lordship's presence and contribution today will go a long way in making the regional conference a huge success. We welcome your Lordships. On behalf of the High Court of Meghalaya and the Meghalaya State Legal Authority, I extend a cordial and warm welcome to all the Honorable Executive Chairpersons of State Legal Services Authorities and to all Honorable Chairpersons, High Court Legal Service Committees present here. I believe they can all contribute to vast experience, and we look forward to having meaningful and fruitful discussions ahead. And a hearty welcome, of course, to the Member Secretary and other officers of NALSA, the Member Secretaries of all the State Legal Service Authorities present here today. I also welcome the Chairpersons and Secretaries of District Legal Service Authorities and other justice officers in the state. Last but not the least, I welcome the representatives of the print and electronic media and request them to give wide coverage to their respective media platforms, considering the importance of this program and the issues that are going to be addressed in the working session. With these few words, I extend my welcome to each and every one of you who have spared available time to be part of this program today. Thank you. Khublai Mithela Jai Hind.
Thank you, Lordship. His Lordship, Honorable Mr. Justice Sanjeev Banerjee, Chief Justice, High Court of Meghalaya, an alumni of St. Xavier's Collegiate School, Calcutta, St. Paul's School, Darjeeling, and the University of Calcutta, practiced in the High Court of Calcutta as well as in the Supreme Court of India, other high courts and tribunals. His Lordship was elevated to the bench of the High Court of Calcutta as a permanent judge on June 22, 2006, and delivered judgments in matters encompassing almost all branches, including important public interest litigation. His Lordship took oath as the Chief Justice of the High Court of Meghalaya on November 24, 2021. May I request His Lordship, Honorable Mr. Justice Sanjeev Banerjee, Chief Justice, High Court of Meghalaya and Patron-in-Chief, Meghalaya State Legal Services Authority, to kindly address the August gathering.
Good morning and namaskar. Justice Kaul, Justice Khanna, my colleagues, Justice Thank You and Justice Dingdo, brother and sister judges from across regions, members of the advisory committee, registrars, member secretaries, ladies and gentlemen. After that spot of embarrassment, let me begin with a different brush. My exposure, first exposure to NALSA was through a program that was conducted late in the year 2006 in the Sundarbans. So there was an NGO headed by a lawyer friend's mother who insisted I must go over there and invited me. I agreed. I didn't know what it was about. And about 7 days before we were to go, she kept on calling my secretary about whether we had informed the police, whether we had informed the district administration and the lot. And ultimately, when everything fell into deaf ears, she called me and said, "Why haven't you informed anybody?" So I said, "I don't use an escort. I drive my own car, and would it be embarrassing for you to join me? Unfortunately, they had to go that way without the paraphernalia. Then is the experience at the carnival kind of atmosphere that was organized deep in the Sundarbans. Though the distance as the crow flies from Calcutta was less than 80 kilometers, we had to drive for 90 minutes, take a launch for the next hour and a half, and then finally a cycle cart to go to the venue from the ghat, as they call it. And there the program was wonderful. And at the end of the program, as it was getting dark, there was this young lady who got up to deliver the vote of thanks. And that was an education that I keep sharing with everybody. This lady got up and said that sometimes we have wonderful Saturdays and bright Sundays, but we go back into our dark week from the Mondays when all of the dignitaries disappear. And in course of one of these dark days of the week, there was a young girl who was raped, and she had to walk 16 kilometers to the nearest outpost to complain that she was raped. And she was advised by everybody, don't do it, it's not worth it. She was told that she might get molested on the way back. She was resilient. She went to the outpost. She complained. Upon receipt of her complaint, she was orally raped. And on the way back, as it was dusk, she was molested. But the bright light that, shone at the end of the tunnel was that the lady said, yet the girl was never ashamed for what happened to her because that was not her fault. And here she was delivering the vote of thanks amidst celebrities and high court judges. Sometimes we do not know the pain, the lack of facilities, the unawareness of rights. And justice doesn't mean anything unless justice isn't, the bit that we do in court. That's important. But as a public servant, you miss the wood for the trees if you don't realize that the ultimate mandate that you have is to uplift the conditions of the citizenry. This wonderful piece of legislation under which we are constituted and we are assembled today gives judges a different role. And we must understand what justice in access to justice means. Justice is not the courtroom. Justice is not the law. Justice is, in a difficult sense to explain it, to remove injustice. And while that is utopian, we must strive towards that. And it's a unique opportunity that judges under this statute and the judiciary as an organization has been given this role, which is completely different from what judges were reckoned to do prior to this act coming into effect. As far as the Northeast and our region is concerned, there are many things which ought to be done, and I requested Brother Thank You to jot a few points down, and some of the points that he makes are remarkable. One of those is that with the technology that we are using now, we must acquaint our PLVs with the technology and to explain the technology to the end users, particularly people who come to make representations, petitions. There must be a synergy between the e-Seva Kendras and people seeking legal aid and wanting to approach the court. The next and the most important aspect is, in places with fragile ecologies, as in Meghalaya, people must be made aware of what they ought to do and not do. You see, traditional folk over here depended on the nature. They depended on their land, they depended on their forests. Suddenly, by a law, we stopped them from using timber in the forests. By another law, we stopped them from using the produce which was in the land. So now you have a menace of rat hole mining where people, because they are not aware, are digging under their very houses without realizing that the mildest of tremor would bring the house down. There is a particular region over here around Clariot. There's a valley and a place called Rimbai over there. God forbid if there's an earthquake of any significant degree of magnitude. The third aspect that Justice Thank You points out is that in a place like Meghalaya where women are very active, they should be made aware of their rights and the remedies which are available. In particular, and as a general rule, I feel that, if we empower our women and take care of our children, a lot of the work which is required to be done would have been done. Finally, we have a social audit law in Meghalaya, and in respect of certain matters like elsewhere, there are public hearings which are conducted. Unfortunately, the very few public hearings which have happened, and I'm aware of what happened in Tamil Nadu pertaining to the coastal region, vested interests would, hijack the program, and they would kind of foist their interests and their, agenda by working on the local folk and inducing them with very, very minor kind of gifts. There, our PLVs could be trained so that our PLVs make the people aware of their rights and the proper stand that ought to be taken in such situations. I'm sure you've not come here to hear me. We have Justice Kaul who will enlighten us on the roadmap that we take, and Justice Khanna of the future. Thank you. God bless you all.
Thank you. Thank you, Lordship. His Lordship, Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India, an alumni of St. Stephen's College and Campus Law Center, Delhi, was elevated as a judge of the Supreme Court of India on 18th January 2019. His Lordship, the nephew of a former judge of the Supreme Court of India, Justice H.R. Khanna, has delivered notable judgments. May I now request His Lordship, Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India, to kindly address the august gathering.
No, I want this on the side. Yeah, that's fine, yeah, that's fine. No, okay, that's fine. I want that way because otherwise I won't be able to. Yeah, thank you. Respected Mr. Justice Sanjay Kishan Kaul, Mr. Justice Sanjeev Banerjee, sister and brother judges, Executive Chairpersons, Secretaries and members of the State Legal Services Authorities, High Court Legal Services Committees, Namaskar and good morning. This is my second visit to Meghalaya, and you always get captivated by the natural beauty and also the warmth and happiness you see on the face of the people over here. The self-discipline is the second aspect which really attracts you immediately. But we have work to do over here, and Justice Kaul had asked me to set the ball rolling, which we did in Udaipur. And I had made a PPT. So those who have been with us will probably feel there's a lot of repetition. But that's the way it is. And I intend to carry it forward. Every time, because of the inputs, I've been making some changes in it. So let's go ahead and begin. If one looks at Section 12 of the Legal Services Authority Act 1887, almost 80% of Indian population will be eligible to seek and get legal aid and assistance. This means India has the largest coverage of legal aid in the world. It's something which probably misses out on several occasions, but we have to be cautious and aware of it, because there are 8 categories which are specified therein. I need not go into all that, but that's the importance of legal aid, which we have been given the statutory duty to undertake and perform. Now, a glimpse of the legal aid system which we have in India. We have the legal services. So we have the Legal Services Committee in the Supreme Court, NALSA, then the Legal Services Committee in the Supreme Court, then state legal services authorities, which are 37 in number, District Legal Services Authority 676, High Court Legal Services Committee 39, Taluk Legal Services Committees 2,361. You can see the expanse, the number of committees. As far as panel advocates are concerned, it's about 50,000, out of which about 4,000 are in the high courts. But what is more interesting is we have about 45,636 paralegal volunteers. And other interesting figure is almost 40% of them, about 19,000 plus, are women. We have in all 12 schemes. Many of them, until unless one goes through the schemes, one doesn't even realize they exist. These are from differently abled children to justice for widows, senior citizens, disaster victims, victims of trafficking and commercial sexual exploitation, workers, then legal services in children and their protection schemes, mentally ill, poverty alleviation schemes, enforcement of tribal rights schemes, and victims of drug abuse and eradication. Probably this is one area where we have to put little more attention, and how do we go about enforcing and ensuring that these schemes are implemented to the fullest. Justice Banerjee spoke about access to justice, and also justice mean getting rid of injustice. Justice, if one looks at, has various different connotations and interpretations. But in our context, as far as legal aid is concerned, it means existence of rules that provide right to a fair and a just decision. Rules that provide an equal and a fair opportunity of winning against most powerful and against the state itself. Because justice cannot be left to merely because if a person has money, he'll be able to have access to justice, because he'll be able to approach the court. First, he'll know the rights, and then he will be able to go to court. One of the things which I noticed, and with my interaction, with little interaction which we have had with foreign jurists, is that there is resistance to legal aid, at least at the appellant level. And the reason is quite clear. They feel that why should legal aid be provided to perpetrators of crime? And therefore, taxpayers' money should not be spent. We have fortunately not followed that path at all. And I believe there are several reasons for them. One of the main reasons is that we believe in constitutionalism. And if I'm not going to refer to Article 38 or 39A, But if one refers to Article 21, it makes it clear. No person shall be deprived of his life or personal liberty except according to procedure established by law. Now, procedure established by law is a very loose term. Procedure established by law has to be fair and just. And that is what is provided then in Article 14, which says, a state shall not deny to a person equality before law or equal protection of laws within the territory of India. So how do we ensure equal protection of laws to everybody? And then we come to Article 22(1), which deals specifically with criminal jurisprudence and criminal courts in India. No person shall be arrested, no person who's arrested shall be denied the right to consult and to be defended by a legal practitioner of his choice. Now, it's very easy to say be defended by a legal practitioner of his choice, but what does it mean? It means that you'll have access to competent legal practitioner. We have to ensure that, and that flows if one refers to Article 14 and then 21. So these three things, these three articles have to be read together if one is to fully understand and appreciate the core of when it comes to trial and the providing of legal aid to the so-called offenders or accused who have committed an offense. I have given in this slide what do you mean by constitutionalism. Constitutionalism, according to me, refers to, in a way, a rule of law, which means that the government is legally limited, that the government's authority is dependent on the enforcement of such limitations against itself. This applies not only to the executive, the legislature, but also to us, that we have to live within our constitutional limitations. But when it comes to adjudication, we have by the Constitution itself been given the duty to ensure that the other two wings, that's the legislature and the executive, live within the legal limitations as prescribed by the Constitution or by the statutes. So that enhances our role somewhat when it comes to adjudication, because we are the arbiters who decide whether it is within limitation or outside limitation. This is important in the context of legal aid because we have fairly robust legal framework as far as investigation is concerned, be it the CRPC, be it the Evidence Act and other hosts of principles of natural justice and other concepts which we have over the years built up. But these constitutional systems reflect on the importance of the legal aid. But what it really happens is, in these systems are properly enforced, if there is confidence in legal aid, then there's a check on the arbitrary use of power, checks on the investigation process, then there is improved quality of justice, confidence and credibility of legal institution enhances. And if one looks at it, it ensures that the society becomes better, more rule compliant, more based upon rule of law and constitutionalism. So moment we enforce in the courts, we become stricter with compliances. It means there's better investigation, better chances of conviction, and there's better governance and better rule of law. As far as access to justice is concerned, I've divided in this slide into 3-4 parts. Access, as we know, but access cannot be there without awareness. And then there has to be ease of access. Now, ease of awareness has to be also, in a way, by the statute has been put on us, apart from the executive. Ease of awareness can be divided into 2 parts. One is merely establishing centers or places where people can walk in or reach in to us. But there will be situations where we have to reach out. And reach out means that we go to the beneficiaries, the institutions go to the beneficiaries rather than beneficiaries coming to us. This is applicable both as far as awareness is concerned, as far as ease of access is concerned. Last aspect relates to tackling apprehensions, because there are two apprehensions which are there. Maybe there are more also, but two prominent ones. One is we are an extended arm of the state itself. And second is with regard to the quality. So these two aspects we have to keep in mind. I have then, in the next slide, given what work we have done, how many legal services clubs are there, legal services programs were organized, how many times we went on the TV, radio, etc. Now, one of the issues will be how to expand the scope of awareness and how to expand the reach in, reach out within because this has to be state specific, maybe even district specific. The other thing is legal services helpline numbers. There was a suggestion given on the last occasion that we should have a national number. There has to be some work in progress which has to be done in this. I don't think helpline numbers have been working very well. Then the legal services helpline desks which have been set up, maybe in jail complexes, etc. I'll just give the data with regard to that. But this is something, and do we go in for a web portal or some other system by which the access can be made easier? It is also relevant whether we develop a software so that we can keep a tab within each state itself or each legal services committee, how it's performing, and then get their data and figures at the national level. In this slide, I've given there 5 stages really of trial. Normally one feels once the charge sheet is filed, there's the first stage, the trial stage and the appellate stage. We have, to some extent, overlooked the first stage, which is perhaps the most crucial and most important stage, because that's the time when the citizen or accused, especially those belonging to economically and social backward classes, interact with the police. They're the most vulnerable. They're the most exploited at that time. Expectations are very high. People put in all their money at that stage. That's a pre-trial stage. So I've divided the pre-trial stage into 3 parts: pre-arrest stage, and the remand stage. And if looks at it, why it is important at the pre-arrest stage is making the suspect feel less isolated or intimidated, safeguarding their rights as per law, keeping in check on police aggression and abuse of power, avoiding unnecessary arrests, gaining vital and immediate time-sensitive information of evidence for the suspect's defense which may not be available after a passage of time, protecting the suspect from being subjected to wrongful self-incrimination contrary to the constitutional or statutory protections. This is figure I had given at Udaipur also, which was a little disturbing. There were about 1.5 crore arrests in India in 2021. And 61% of these arrests were under CRPC provisions. Arrest doesn't mean that they were sent to jail. They were formally arrested, maybe released even on bond. And 39% arrests were only made, were under the IPC and the state law. So we have to, in this process, some gap arises. Are we providing legal aid even at that 61% state to those 61% arrests? This figure of 1.5 is rather huge for the simple reason that means almost more than 1% of the Indian population got arrested in some case or the other, which is in 2021. It's something which has to be looked into, though not within our domain completely. As then we come to these are the data with regard to the prisoners. About 18 lakh persons were admitted to prison. This will include the internal transfers, returned from leave, etc. But the convicts were only 6% who came into the prison. 94% were under trials who got admitted into prisons. But the other thing is total number of people who were released from prisons in 2021. There were 15 lakhs. So there was an addition of 3 lakh people to the prisons in the country in 2021, which means there's something wrong. The system is not working fast enough. The system is not able to cope up. The intake is more, outtake is less. And if one looks at the total number of prisoners at the end of 2021, they were about 5,54,000, out of which almost 77%, that is 4,27,000, were under trials. So there's something here we have to focus on. How do we ensure that the justice is delivered fast? This also deals in a way not purely with the NALSA, but with our judicial system itself. We are all aware of DK Basu guidelines. I'm not referring to those. How do we integrate our system into the DK Basu guidelines so that we have real-time access or real-time knowledge about the arrest of a person? And because only then we'll be able to interact at the pre-arrest stage. I'll just clarify this thing. Section 12 uses the term custody. It doesn't use the term arrest. Custody is a wider term. So our role begins from the day you are called by the police. Somebody is called by the police for interaction or maybe even for statement or as a suspect. The remand stage, I'll just skip this a little bit. But if one looks at the data with regard to between 2019 to September 2022, about 11,000 suspects were provided legal assistance at the pre-arrest stage, which, keeping in view the number, is rather low. Then we provided legal assistance to about 10,000 people at the police station, but the figure really jumps when it comes to remand stage. It went up to 1,13,000, which is a good sign that at least at the remand stage, people are taking recourse to legal aid. About 39,000 applications were filed, 19,000 people got bail. We have over the years now evolved what is called the modified scheme for legal aid defense counsel system. There are various parameters. Everybody will be discussing about it. We have, in the next slide, given what all we have been doing. One thing about thing which perhaps requires a little more attention is to visit to the jails. It has to be done periodically. Timelines where the timelines should be fixed, and those should be implemented. And how do we ensure that the reports are submitted and then sent to the committees or the authorities, etc. So this has to be checked. Are we doing that? Because there is a skill development also which is important, which will be referred to subsequently. Then this is the data with regard to how we are trying to evolve the new scheme, and by the end of March, probably every will be completely covered. These are the issues which may arise as far as legal aid scheme being implemented is concerned. It means physical infrastructure, human resource, eligibility criteria, capacity building, outlining the standard operating procedures, challenges in finding solution, resizing the panel, filing of appeal, reasons for delays, finding solutions, monitoring the adequacy and quality of legal aid and advice, working of mentoring and monitoring committees, effectiveness of handbooks, parameters to be determined, so on and so forth. One thing I must point out over here, some suggestions were received that we can have committees in heinous and serious crimes which can guide the councils how to go about. Another thing which I noticed as a judge of the High Court was the number of habeas corpus petitions which are coming. I did utilize with great satisfaction the legal aid councils to interact with both the boy and the girl and the parents with great degree of success. Invariably, all of them are a little reluctant to open up, given the fact that we sit on a chair and we are not known as really citizen friendly that way. So that I found was extremely helpful. You allow them to interact. Do we go ahead with it? How do we go ahead with it? And even whether we should implement it in the trial courts where the magistrate calls and records a statement. How do we take help, or do we take help of counselors, etc.? Then on the schemes, I have noted down 6 schemes which may be of some relevance, because one of them, protection and enforcement of tribal rights, may be of some significance in many of the northeastern states. But coming to the other schemes, we have victim compensation scheme, which has been to some extent being implemented fairly well, but there are also problems coming up which we have to be cautious about and ensure that those problems do not derail the scheme. I'm not going to read that, but you can understand probably most of us are aware of these victim compensation schemes. This gives a figure of how many applications. These are all India figures from April 2022 to December 2023, which shows that almost total number of applications received were about 27,000, 14,000 were decided, 16,000 so and so were pending. The other issue which is of some concern is of witness protection. I had, as a judge in the Delhi High Court, in one of the summer vacations, carried out, examined and collected data with regard to about 116 matters which I had the occasion to decide. And I found almost 38% cases, the public witnesses had turned hostile, which is a very large number, and that too in a state like Delhi. I had then bifurcated the reasons why they possibly turned hostile, and also bifurcated how do we go about it. Now, under the Witness Protection Scheme of 2018, we have to first go into the question, determine the need, extent, and cost of police protection, assess the nature or risk to the security of the witness, intensity of investigation, gravity of the testimony of the witness, and then the range of protections I've given in the last column in the first one, which includes temporary residence in a safe house, new identity, so and so. I don't think it's ever been implemented as far as I know. Maybe in some case or the other, odd case or the other. This is the data which I pointed out, which I had done. 37.9% in 44 cases, and almost 62% witnesses were material and important. 12 were crimes against women, almost 27%, 28% were crime against women cases. Now, the other aspect which we have now been asked to perform, which is mediation, which perhaps is very close to northeastern states, as per Section 12A of the Commercial Courts Act. I've given the details of the mediation centers which we have set up. There we can divide mediations as per in terms of the mediation rules 2018, which we have set up. Successful resultant means where there's a success, non-starter where the parties do not come forward and withdraw themselves before, and failure means when the parties, it's not a non-starter case, it's a starter case, but you don't achieve the success. These figures are with regard to pre-institutional mediations under the Commercial Courts Act. Figures are not very good. 1920, 167, 2021, 186, 2021 is 368, but 2023 up to September 2022, we have gone up to 473. One very heartening sign is every year it's improving. So we should not get disheartened. In fact, we should do it with more vigor and in short. Now, these are the figures which I have given, or something which Justice Kaul has been, something which has been very dear to Justice Kaul, and I was also associated with the district legal services mediation centers in Delhi. There, the success rate, if you look at, is, as far as the High Court is concerned, from 2006 to 2020, it's 14 years, is almost 47.6%. That means almost 50% cases were decided successfully in mediation. And this mediation is done purely by the advocates without the judges getting involved. As far as district courts is concerned, probably because there were more matrimonial matters over there, the figure has gone to 68.1%, which is a very, very high success rate. So somewhere we'll have to. The other aspect which has been of some concern is community-based mediation, which we have not yet picked up.
Message 2.
So,
Attention, please.
Am I exceeding my time? So I'll close it up. Okay. This is we have one society which has been doing this, but this is really important because several small disputes can be resolved. These disputes can be special education, minor complaints, consumer, workplace issues, accident compensations, police citizen, minor criminals, so on and so forth. Then we have the benefits which I have listed of community case mediation. There is a recent order passed by the Supreme Court, or recent proposal given by the Chief Justice of India relating to Sri Seva scheme, which will be applicable to the women, for women. It is pointed out that in almost 4.4 crore cases pending across various courts, 38 cases are filed by women. There is another little surprising figure with regard to which was given there. It shows that more women are filing criminal cases compared to civil cases, probably reflective that they are not participants in the civil, on the civil or commercial side. The figure goes up very high when it comes to the High Court.
Message 2.
Then with regard to premature release, is again an issue. We have set up
2.
this premature release guidelines have been fixed. We are providing legal aid at that stage. There are 14 categories of cases which can be reviewed by UTRCs, which have been set up in terms of the Supreme Court judgment. UTRC stands for Under Trial Review Committees, which consists of district and session judge members of 4 different members, and they take it up, follow it up. Then this figures gives how many of them have been looked into and how we have gone about. Then rehabilitation and reformation is again an aspect which has to be given focus, probably by involvement of NGOs and third parties. I don't think we'll be able to handle it on our own. Then the other issues with regard to probation, which is something which has not really picked up in India. And how do we enforce, do we get into the probationary officers' laws, social reports, etc. Lok Adalats is one thing where we have done fairly well. We have to continue with that. I need not elaborate on that. I hope we have on all these topics we'll be able to discuss openly and we'll be able to carry it forward. Thank you.
Thank you, Your Lordship, for your kind words of wisdom on access to justice and the need and way forward to reach out as legal services institution. His Lordship, Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India, and Executive Chairman Nalsa, hails from Srinagar, belonging to a family with distinguished career in public service. His Lordship, an alumni of Campus Law Center, Delhi University, practiced mainly in the commercial, civil, writ, original, and company jurisdictions of the High Court of Delhi and the Supreme Court of India. His Lordship was elevated as a judge of the High Court of Delhi in the year 2001 and appointed as a judge of the Supreme Court of India on 17th February 2017. His Lordship has delivered notable judgments. To mention one is in favor of right to privacy being a fundamental right. Now, may I have the honor to request His Lordship, Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India and Executive Chairman Nalsa, to kindly present the inaugural address.
Very good morning, brother judges and sister judges, members of the judicial fraternity, ladies and gentlemen. It's a great privilege to be here in a beautiful part of this country and amongst friends. On a personal note, Sanjeev Khanna is somebody who has been my junior right through school, college and faculty of law. And my successor in terms of the Legal Services Authority in times to come. And I think we are making an endeavor that the whole approach to legal service authority should have a long drawn perspective, because it's not a task to be achieved in a day or in a year, and the continuity is necessary. Sanjeev, and that's the way he has always asked me to address him, so I address the Chief Justice in that manner. My association goes to him from especially Chennai days, where he led from the front and got the affection of both the bar and the bench. A wonderful job done. So I think the state, the High Court is privileged to have him as a Chief Justice of this court. Coming to the topic at hand, as far back as 1964, Justice Hugo Bloch said that there can be no equal justice where kind of a trial a man gets depends on the amount of money he has. It is with this objective in mind that the Legal Service Authority Act was set up, and the whole objective is that to the large underprivileged section of this country, whose in percentage the number is high and absolute numbers are also very high, there should be a sense of belief of equality in terms of legal assistance, and because they are found to be at the brunt, at the receiving end. If one looks at the figures, and let's begin by some of the hard facts which emerges. Mrs. Khanna gave you the data. But around 70% of the under trials are from the socially vulnerable section. 29% were found to be illiterate as per data. 41% had not completed the 10th class. And 72% of the under trials belong to socially vulnerable categories of the scheduled caste, scheduled tribes, and other backward classes. So impoverished and marginalized groups often bear, as I said, the brunt of the arbitrary arrest, detention, and custodial violence, while procedural protection built into the law through the medical practitioner and magistrates are often violated. The range of the structural barriers plaguing the system, including indiscriminate arrest, a restrictive bail regime, and delays in investigation, all result in the large proportion of socio-economically vulnerable under trials in India. This continued detention is something personally which has troubled me a lot. And this is despite our endeavors as an institution and personally to pass various judgments to see that we don't convert in our belief that we cannot achieve a conviction, therefore the only way of punishing somebody is to keep him as under trial. Unfortunately, I find that is also sometimes the judicial approach. And this judicial approach, honestly speaking, instead of watering down, I find it seeping upwards, to be very frankly. And we must be conscious of this as judges. That when we are dealing with this vulnerable section of society, the ultimate objective is to have a trial, conclude the trial. If somebody is there, punish him in accordance with law. This continued detention, long years after the person has been detected or charged with a crime, is something which is very difficult to fathom. Even at the Supreme Court level, we find for offences for, say, a maximum sentence of 7 years, the person has been in custody for 5 years without bail. Trial is not complete. First stage is not complete. Just before coming on, one of the petitions which came before us was only on the age of juvenility. Of course, this is a plea sometimes raised belatedly. But the fact is the man has gone through 11 years of custody already when the plea of juvenility is being raised. Now, if it is, I don't know what the result would be, if it is found that way, what is the result we are looking to? Is it that he should have been given assistance at a particular stage of time which has not been made available? The lawyer was practically appearing pro bono, and I know he takes up cases of this nature. So somewhere somebody did not flag the issue. Therefore, it's important to flag issues at the relevant stage, and that is one of the aspects the Legal Service Authority is looking to. The fact is that the procedure envisaged, the time envisaged, the cost envisaged make it difficult for the people to go through a long and expensive process of combating the excesses. And that's why the importance of NALSA increases in trying to help them, because we can't suddenly shorten everything. That's not possible. The volume of cases are such, the procedures are such, the way the system goes on is such that unfortunately we can only try to build up that assistance, and that assistance should be of requisite quality is a very important aspect of the NALSA. There is a confluence of factors responsible for this problem in this access to justice. Affordable legal assistance, guaranteeing fair trial, upgrading the skills of the legal service authority lawyers, training for them. Because sometimes the feeling is that the lawyers assisting the legal service authority are mostly young lawyers who are wanting to make a career, and those are persons who want to get the exposure. Well, there are two aspects to it. I do believe that some of the younger members of the bar are far more enthusiastic. The generation today is far more enthusiastic of how to give assistance, so there's no harm in it. But then there must be upgradation of skills and assistance at an appropriate stage by experienced lawyers. These are some of the glaring facts which stare us. And at the same time, we can't be cynical. If you do something well, let's appreciate it. The time passage required for doing our task is long, but while we should flag issues, I think we should also in some way appreciate what we have achieved. Therefore, some of the aspects which I wanted to, just have a brief discussion is, what is that we are doing? The work of legal aid in India has been, to some extent, I would say, revolutionary in character. Started from a very limited perspective, if you see, and today has expanded into a huge different dimension, I would say. The kind of schemes, 6 schemes, we are today looking to particular schemes, particular areas, and the whole concept of regional conferences arose because while there is commonality of certain problems, there is also distinction of certain problems dependent on the area where there is. It has been our endeavor to carry, when we talk about legal aid to the household, to also carry the discussion on legal aid to the different regions. And in that region also, we've made an endeavor to see that places where this kind of a conference is not being hosted should be the host. Every time pick up a new venue to do it, so that there's a sense of belonging to different states and areas of what we are trying to achieve. On the positive aspects of the data are that 50,000 prisoners were released under the UTRS recommendations. 1,92,244 prisoners, or 34% of the total prison population 2021, was provided legal services by the Prison Legal Aid Clinic. 91,000 prisoners were provided legal aid lawyers. And these numbers also highlight 2 key points. One, the poor state of private legal representations for persons in custody, and second, the extent of socio-economic vulnerable persons in our prisons. Legal service institutions have less to do with the former, but our work for poor prisoners does not stop at giving them legal representation. There are various aspects in which this operates. I had an opportunity some time back to go to Jaipur to visit the open jails. A very unique endeavor, and Rajasthan is known for having more and more number of open jails. I went there, interacted, saw where they were staying. So these are, much could be done to improve the environment there, which is what I flagged. But the fact is that people who have conducted themselves well in prisons after their fault in process in life which has occurred, are sent there, and they lead a normal life with the family in a part of the day. They go out and work, but are supposed to come back. So the open prison is that the area, they build their own house, they keep their own process, they're given certain facilities, but they earn their livings. They earn their livings by going out and working, and there are groups and private corporates and otherwise who provide them the opportunity dependent on the skill they have acquired. So you help them assimilate with the society through a slow process, rather than releasing them after 14 years suddenly and trying to assimilate them. Yet maintaining the discipline that they don't get back to another crime. So these are all innovative ideas which can be expanded. If we see something there in one state, we can look to how that can be implemented in other places. The LADS breakthrough has a long run ramification. I think the most important aspect is to innovate new paths, when I took this example, and work in the legal service institutions by looking to solutions for problems at the base level. In this whole, when we talk about lakhs of cases being settled, one used to feel, well, if lakhs of cases are being settled sometime in the Lok Adalat, why are we still burdened with so many lakhs of cases? Why can't we sort it out at the same pace? Some process, I do believe, is collection of data and statistics. But the fact remains that we are also working at a plea litigation stage, because ultimately mediation in some way is also part of the NALSA. Though there's a separate MCPC, I am fortunate to be heading both of them, to assimilate both of them in some way. And I am, as Justice Khanna said, I'm a great believer in mediation, because a lot of problems arise in the society because smaller disputes are not sorted out at the base level. If we are able to sort those problems out, we talk about criminal offenses, but if they often arise from civil disputes at a base level. If we are among the vulnerable section of society, able to address the issue of the civil disputes, I'm confident that the resorting to crime would be less. And the court systems in our people, the worrying part is, why is there growth in criminal litigation and not such a growth in civil litigation? People feel that the civil litigation takes a lot of time, so it will never come to an end. And the lawyers will advise them how to invoke the criminal jurisdiction to give the civil dispute a color of criminal dispute. This is a large section. I was wondering, for example, that a lot of women are resorting to the criminal jurisdiction, as Brother Khanna said. But that's also occurring because one is awareness. They're more aware and willing to do so. Sanjay provided the guiding light. Example is bare and staring. So the enlightenment, I think, was provided by him when he began with his lecture. That's one aspect of it. The second aspect is legal ingenuity of lawyers. Every matrimonial dispute has what I call a bouquet of cases. And 2-3 criminal cases, 2-3 civil cases, and ultimately when they do come to Supreme Court, the only way to settle is we send it to mediation, and the success rates are fairly high. And all these 5, 6, 7 cases disappear with it. I have judicially called that, I quashed the bouquet of cases which have been filed. I don't think the parties are really interested. So you will, even if there is a dowry dispute, somebody will rope in every known, unknown relative of the boy's family. And I have noticed this practically. If one person from the boy's family goes behind prison for a day, the hardening of the stands is so much that it becomes far more difficult to reconcile the situations. So for the purpose which the criminal jurisdiction should be resorted to is resorted to less, and for which it should not be resorted to, it gets resorted. That's the problem which arises in the manner in which the legal system works and how the advice takes place. Now, the NALSA is creating an online mechanism based on e-prisons network which could automatically alert stakeholders. I think it's a very innovative method. We suddenly found that a large section of prisoners who had been granted bail were still in prison because they could not meet their requirements. Now, nobody knows that they are still unable to give the bail bond or unable to give the bail security. So the system, when it operates fully, will have some kind of a 7-day period after which it flags the issue. So the legal service authority can go and say, well, even after 7 days, if he is not released on bail, there must be some reason for it to check. Invariably, it will be because some condition is not met. So we can take out this whole category of cases where people, despite judicial discretion being exercised, are not able to avail of it. Updation, adaptation, upgradation, enhancement of mediation at the block level, I think, which I flagged, is a very important part. I do believe that legal services, in a sense, go hand in hand with mediation. Both processes can assist in ultimately resolving disputes at base level. And my faith in mediation is because people do not understand the niceties of law. The people of law understand the niceties. What is justice? Sanjeev tried to flag in the beginning. Ultimately, that must know that if he wants X, why he can't get X or why he gets Y. The legal system in a legal jargon will tell him that you get Z. And he will not know what is the reason for it. So mediation endeavors to see what a person wants and to find the needs of a person. That's why you begin a mediation training with the example of a orange and saying that, look, the court, if it has to give half and half, will only divide the orange and give it away. While the mediator will find out if somebody wants to use the juice for baking a cake and somebody wants to make a marmalade out of the rind, you can divide it in a different manner. So people are often, as they said, the difference in the status by the chair and the podium we preside over makes them hesitant. I'm a person who's gone through mediation training myself at base level, at advanced level, numerous times. And I personally felt it helped me do my performance as a judge better. So we are even looking to training of judges for referrals and training of judges for other purposes through the mediation process. I would encourage all the judges, because we on the second role of NCPC are saying that let everybody go through a mediation process training to improve our skills. I used to always say that a lawyer is representing this party. Sometimes you'll see this party bobbing up at the back, raising their hand. I was a person very reluctant to permit anybody to speak. Through a mediation process, I realized maybe he feels that the lawyer has not exactly said what he wants or what his grievance is. So without giving him some elongated time, once in a while to give him just 2 minutes to be able to say what he wants is important for him to have the satisfaction of what it is. I last time related the conundrum of this understanding of a litigant by giving an example related to me by one of my friends and colleagues at the bench, and I repeat it again. For those who had been there, they understood it. So I told them that he came and once told me, look, outside the Delhi High Court, there are kiosks of different kind where food is served and different cold drinks are available. So one of the litigants, who must have been an extremely unhappy man coming out of court, went to one of the places and instead of whether he ordered a cold coffee, some kind of a milk was given, or a milk and coffee is not important, but he was given something different from what he wanted. So we asked him that, what is that you have given me? That fellow said what he'd given. He said, what did I ask for? He asked for something different. So I'll translate for benefit of people who don't understand Hindi. But in Hindi he said कि ये पिछले जन्म में जज होगा, मांगो कुछ देता कुछ और है. He must be a judge in some other avatar, because you ask for something else, he gives you something else. That's the fate of our litigants, And the whole system, we keep forgetting, works for this. The bar exists, the bench exists because we want to provide an avenue for people not to take law into their own hand and fight physically, but to find a solution to the problem. It's a solution-problem issue. Therefore, we have to find a solution to this, keeping aside the part of the criminal jurisdiction. But even in criminal jurisdiction, there are a lot of civil nuances at times, which form the basis of the criminal jurisdiction. You will find often cases of hurt, grievous hurt arising where? My experience in Punjab, Haryana, Chennai, they are all disputes relating to land, some waterway, something to do with the agricultural methodologies. Land disputes are a very large part because the land records are so poor. we still don't want to do without technology today, because the power of the Patwari or Tehsildar will go away the day there is a proper demarcation which takes place. We've had scenarios in Delhi where we found that the consolidation officer was the same person for 20 years in a village who gave up his promotions because the most lucrative job was remaining as the consolidation officer to shift land from there to here. These are all problems which we have to flag. And we have to keep innovating with every, I think, meeting, every interaction. We will come up with new ideas and I think come up with different forms. There are also some other cases which I wanted to forward. One was Motor Vehicles Act cases, a large number of funds pending, how to improve it. Well, we have, through judicially now, flagged this issue, and all the insurance companies and the stakeholders, the police, the victim are there. So an app is being developed, almost finalized, which will operate at a national level. And the central government and state governments are also on board on this issue. So that will help in a reduction of cases from registration of the accident to the disbursement of compensation. There are thousands of crores of compensation lying deposited in courts which are not being disbursed. Chennai research was done, a huge issue, and that when such funds lie becomes an avenue for people to break into the system to somehow, all kinds of issues arise in that. Now, those are problems which also require to be addressed. One of my colleagues recently said, and I'll pass on it to the Legal Service Authority, where is doing a research that how many cases with amounts of compensation really of 1 or 2 lakhs in appeals are pending, where the insurance company, where the order of the court below is pay and recover. Still the insurance company has gone in appeal. So he said, why can't insurance companies through the Legal Service Authority be persuaded to withdraw the appeals? In taxation, the government says if the stake is above something for different courts, we will not contest. Should insurance companies be contesting these cases, especially where there's pay and recover orders, if the other party has not come? So this is something which was put to me only yesterday. And then we have, in the Lok Adalats, apart from the small number of disputes, flagged issues where there are problems relating to the smaller aspect of base level society which is done. So somebody's ration card is not being made, something else is not being made. They have all potentiality to go into litigation. That's why helping and using paralegal for them is extremely important. Just for your information, one of the largest areas of disputes, at least in 2 states, which was Punjab and Haryana and Tamil Nadu, which I had an opportunity to preside, is motor accidents claim cases. Should this be an area of litigation which should pend? Money comes at a stage when they really don't need it that much. When they need it, it doesn't come. In Punjab, Haryana, I remember the statistics of when I was there of 270,000 cases pending, out of which 35,000 were motor accidents claim cases. Similarly, Chennai had similar figures of motor accidents claim cases. These are areas how we can reduce the burden of the courts. Ultimately, in no system, I think, we can achieve if every case has to be fought from the lowest to the highest court. A US system provides for 3% cases to go on trial. We take 99.9% cases to trial. Of course, government is a great contributory to it because they are more than 50% litigant in some way or the other. So the government has to also walk, to my mind, hand in hand to reduce this amount. Maybe this mediation bill has been receiving consideration for the last 2 years. I'm hoping that this year it will say. In what form, I don't know, because the Supreme Court had a role to play in it, in the sense that we constituted the expert mediators committee. They took help from all the experts across the world and made a draft bill. It's a unique endeavor of sending it to the government as a suggested legislation. It's been 2 years hence. The parliamentary committee, with respect, mutilated it beyond recognition, I think. And then the government sent it to an expert committee again to look into it. I'm hoping this would see the day as and when the parliament works on the issue. So that, because we are committed to the Singapore Convention where we have to bring this bill in. I'm sure if it's institutionalized, again, this will walk hands in hand with the Legal Service Authority to do something. You people have an opportunity to debate, discuss the problem of this region and this area, flag the issues which exist, and I'm sure that will be added as a data for us to proceed further, looking after your needs as well as the needs of different areas of this country. think I've taken more time than necessary, but in any case, thank you very much. And once again, thank you for the opportunity. Let's walk hand in hand. There are still miles to go. Thank you.
Thank you, Your Lordship, for enlightening the August gathering with your words of wisdom on access to justice. Access to justice for the youth peace, especially socially vulnerable section, the duty of legal services institution to provide quality legal services and mediation. Thank you, Your Lordship. May I request His Lordship, Honorable Mr. Justice Sanjay Kishan Kaul, Judge Supreme Court of India and Executive Chairman NALSA, to kindly release the newsletter of the Meghalaya State Legal Services Authority titled New Light Issue 7. May I request Honorable Lordships on the dais to join His Lordship in releasing the newsletter. Thank you, Your Lordships. May I request His Lordship, Honorable Mr. Justice W. Diengdo, Judge High Court of Meghalaya and Chairman, High Court Legal Services Committee, to kindly propose the vote of thanks.
A very good morning to all who are present here. With due respect to His Lordship, Honorable Mr. Justice Sanjay Kishan Kaul, Mr. Justice Sanjeev Khanna, our Chief Justice, Justice Sanjeev Banerjee, and my colleague and friend, Mr. Justice H.S. Thank you. I deemed it an honor and a privilege to be given the task of proposing the vote of thanks. Before I proceed, I am reminded of what my friend Justice Thank you told me the other day. He said, as far as vote of thanks is concerned, after going through this inaugural session, it is like consumption of a sumptuous meal. And the vote of thanks, he said, is like a dessert, or the rasgulla at the end of it. So I would take it that it is meant that it should be short and sweet. I will try to keep to that. However, after being here, listening to the distinguished speakers, enthralling us with their wisdom and knowledge, I am overwhelmed at the deep insight and the practical aspect and guidance of His Lordship, Mr. Justice Sanjay Kishan Kaul, the Honorable Executive Chairman NALSA, in his discourse. Thank you, sir, for your valuable advice and guidance, and I believe that would serve us in good stead as we progress through the day in this program. I'm also amazed at the effort and industry shown by His Lordship, Justice Sanjeev Khanna, to such an extent that we have even got a message to keep our attention to His Lordship's address. Thank you, sir, for reminding us the various aspects of legal services. And our Chief Justice has struck a chord, I would say an emotional chord, in each and every one of us when he has cited that poignant example of the young girl. I think that should make us realize the importance of the task at hand as far as legal services is concerned. Thank you, sir, for reminding us. My colleague and friend, Justice H.S. Thankyu, is to be commended for the tireless effort that he has put in to make all the arrangement as we see now. It is indeed a befitting stage for this august gathering to be here. And for this, we should commend His Lordship for the effort that he has put in. I also would like to acknowledge our gratitude to all the distinguished members of the advisory board who have taken their time to be present with us today. Equally important is the presence of the Honorable Executive Chairman of the State Legal Services Authority, the Chairperson of the High Court Legal Services Authority, who, as I said earlier, in spite of your busy schedule, have made it a point to be present with us today. Thank you all for your presence. And I do believe that your contribution would be meaningful and would go a long way in the development of legal services activities in our region. We are also grateful and thankful to the presence of the Member Secretary Nalsa and her team who are present here. Thank you for being with us. And Member Secretaries of the respective state legal services authorities, thank you very much for your contribution and for making it to come and be with us today. I am also thankful, and I'm reminded to make it a point to say thank you to the state government for their continuous support and effort in making this program what it is today. We are also very thankful to see in our midst the Learned Advocate General, I believe, who is representing the state. Thank you, sir, for your presence here. The Registrar General, who is also the Member Secretary of the State Legal Services Authority, has put in sleepless days and nights in his effort and work to make this program a success. Thank you, sir, and also to your team for making this program what it is now. The officers and staff of the Meghalaya State Legal Services Authority, thank you very much for all the nitty-gritty that you have taken part in, especially arranging making it easier for every one of us to take part in this program. Members of the print and electronic media, without whose presence whatever we discuss here may not travel beyond the four corners of this room. Thank you very much for your coverage, and we know that you will continue to support this great cause. Thank you very much for being patient through this morning session. Thank you.
Thank you, Your Lordship. With the permission of the Chair, may we conclude with today's inaugural session. And may I request honorable dignitaries, ladies and gentlemen, to kindly rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you. May I request the officials from the Meghalaya State Legal Services Authority to kindly escort their lordships, dignitaries, ladies and gentlemen, to join for a group photograph in the lawn outside the pre-function area. Thereafter, high tea will be served for your lordships in the Tango Hall. High tea for the member secretary, SLSA, dignitaries, ladies and gentlemen, is arranged in the pre-function hall. And may I request ladies and gentlemen to join for the first session after half an hour. 12:30.